The public narrative tells a specific story. The New York Times suing AI developers is an existential battle, an all-out war for the future of copyright. Institutions and public perception price the odds of this courtroom war happening at 85%. But that 85% is noise. If you ignore the headlines and look at the underlying mechanics, you find an empty space where a legal battle is supposed to be. Obsessing over this theatrical war keeps our attention locked on the courtroom. Meanwhile, the actual future of artificial intelligence is being quietly resolved outside of it. Look at the federal level. White House executive orders meant to wrangle AI policy are delayed. Comprehensive bills like the Trump America AI Act are paralyzed by gridlock at the Capitol. States try to step in, passing child safety laws to regulate algorithms, but federal courts consistently strike them down under the First Amendment, citing precedents like NetChoice versus Merle. It's time to evict the idea that lawmakers or judges are going to step in and govern this technology. The legal cavalry is not coming. Because the regulatory apparatus is completely stalled, it functions only as the illusion of a boundary. The daily operation of AI training and deployment continues without interruption. This infographic from Kalshi tracks where private capital is actually placing its bets. Right here, the market predicts a quiet settlement at a probability of 0.68, or 68%. That creates a 17-point gap between the loud public narrative, pricing war at 85%, and the reality of capital movement at 68%. This gap exists because of a structural shift in how these companies operate, law as an optimization variable. AI labs no longer treat copyright fair use as a hard boundary. It is simply a negotiable cost on a spreadsheet. We saw this solidify after the Anthropic lawsuit. Instead of fighting to a final ruling over fair use, they settled. That reset the entire ecosystem, creating a permanent template for private bilateral licensing deals between AI companies and publishers. The financial scale of this architecture is massive. Publishers like Dotdash Meredith are already securing annual licensing floors of $16 million just to feed their data into AI training models. The core questions of whether AI violates copyright will never see a judge's final ruling. They are bypassed entirely, absorbed as private economic transactions. While corporate economics get neatly resolved behind closed doors, households are left inside an unbroken loop. AI systems flood our feeds with synthetic outputs, extract our behavioral data, and use it to train the next iteration. The math behind this human impact is precise. We are looking at a 72% adoption rate for AI companions among teenagers, operating alongside a baseline where 30% of high schoolers report persistent feelings of sadness. The algorithms driving this digital environment are optimized exclusively for engagement density. The human psychological cost simply isn't factored into the equation. Because private capital bypassed the court system to build a lucrative licensing architecture, this data extraction engine keeps running. It faces zero regulatory friction. We are approaching a strict time-bound collision. An overdue evaluation of state AI laws from the Commerce Department is crashing directly into an April summary judgment deadline in the massive OpenAI multi-district litigation. This pressure forces the entire system down one of two paths. Either the federal government suddenly steps in to create uniform rules, or this private settlement architecture becomes permanent. You can test this yourself. Ignore the headlines. Watch the private prediction markets, specifically the contract pricing the New York Times AI lawsuit on Kalshi. This chart plots the market trajectory we're tracking. If the private price drops below that 0.58 threshold right before the April summary judgment, the debate is over. The corporate licensing model is permanently cemented as the law of the land. It's time to shift your focus. Stop participating in the loud public debate, and stop expecting a regulatory savior to appear and protect the household. Navigating this environment requires looking past the noise. You have to track the quiet, absolute movement of private capital.